to that, the advice that I've been able to give is that someone has to wait 2 years and make an application under Section 6C of the Guardianship of Infants Act to be recognised as a parent of their own child if they're not the non-biological parent, which, you know, is very, very stressful for people. I mean, they, you know, there are so many things that could happen. Nobody wants to have to wait 2 years to be able to be registered as the parent of their own child. So the commencement of Section 2 and Section 3 of the 2015 Act is obviously very, very welcome. Just to give a brief oversight, because I don't know how much people know about the Guardianship of Infants Act or don't know. And so I'm going to start from the premise that people don't necessarily know an awful lot about it. But the Guardianship of Infants Act is of 1964 is basically the premier act in terms of dealing with guardianship, and it's been amended, and it's been amended very significantly by the 2015 Child and Family Relationship Act. And that deals with who can apply to be a guardian. And at the beginning, it was quite restrictive. It was dealt with by Section 6, and it really applied to the parents who were almost married. And then we had Section 6A, which allowed non-married fathers to apply. But for a long period of time, there really wasn't any development in terms of that. And we've had a lot of developments in recent years, obviously related to, you know, marriage equality, and just related to the fact that families are different in the 21st century and we have to adapt to that. So there were a number of provisions brought in by the 2015 Act. But there was a provision to allow parents or non-parents who had lived with a child either for 12 months, so this is Section 6C. I don't want to, you know, I know all the sections are going to run into one another after a while and everyone's going to be like confused, but under Section 6C to allow people who weren't the biological parents of children to apply for parentage. But in terms of the LGBT community, LGBTQI community, the most important development has been the intended commencement of Part 2 and Part 3 of the 2015 Act. And that has been implemented by Statute Instrument 451 of 2019 Act. So that's going to make a huge difference in terms of families in Ireland that want to ensure that both parents have legal guardianship. Now, guardianship, and again, I don't want to go into massive detail, but it is sometimes difficult for people to understand what guardianship is. Guardianship is effectively parental rights. It's effectively being recognized as a parent to the child and having the rights and responsibilities of a parent. So it is hugely significant. And there are other things that flow from it in terms of custody, in terms of access. But, you know, if you are in loco parentis of a child, if you are effectively raising a child and you don't have parental rights, then that is, you know, something that is very significant in terms of causing stress and causing difficulty for people. So having a mechanism whereby we can recognize 21st century families and say, right, this is the reality and we need to legally recognize that is hugely significant. So I think it's very welcome that, you know, the commencement is going to take place in early May. Now, obviously, with COVID-19 at the moment, we're not sure how that's going to work in terms of the court practice and how that's going to be dealt with. So there could be a period of several months where we're not sure how those applications are going to be dealt with, what the what court services are going to do. So there is a degree of uncertainty around this, and I think it would be irresponsible to say, once this is commenced in May, that's the end of the situation. You just make your application, and everything will be fine. We're just going to have to kind of see how this unfolds. But it stems from the 2015 Act, which is the Child and Family Relationship Act, which is a massive, massive, massive amendment to the 1964 Act. So it is a massive expansion of what Section 6 covers. And Section 6 is guardianship. Section 6 is your entitlement to be recognized as a guardian. And I mean, in lay terms, that really means, having parental rights. So, it hasn't come into force yet. So we're still waiting to see how that will play out. But ideally, it covers areas that previously the law hadn't covered, lacunas the law hadn't covered. So, hopefully that will be make a huge difference for people. There are a lot of people that it won't cover, but this was something that particularly discriminated against people who were LGBT because, and a father who wasn't married to a mother could bring this application for guardianship years ago. But somebody who's in a committed relationship with their partner and is not the non-biological parent of a child, if the child is conceived by way of DAR, which is assisted reproduction, they weren't able to assert their rights. Now, there was kind of I don't want to get into sections and subsections as much as possible, but there was a provision which allowed that if they had been in loco parentis, or if they had been living with a parent, they could bring an application under Section 6C, but it is convoluted. You have to put the Child and Family Agency on notice. It is difficult. So this is going to be a huge development in terms of, I suppose, allowing families to regularize the situation that they're in. So I suppose, firstly, we deal with the 1964 Act. As I said, it's been massively changed by the 2015 Act. And without boring anybody, there is a really, really helpful annotated guide to the Acts on the Law Reform Commission website, which inserts all of the changes that the 2015 Act bring in to the 1964 Act. And if you need to go to the law, that's a really useful starting point. I think what is essential to consider is Section 20 of the 2015 Act, which sets out the criteria of a child that can be considered in terms of this. And it's important to remember that this is primarily in terms of, I will say, DAR, but it's assisted reproduction, donor-assisted reproduction, because the Act already provides, and this is already in law, that if you are legally married and you adopt a child, even if it is, a same-sex marriage, there's no distinction. You're already a guardian. And it also needs to be said, because again, I don't know if people are fully aware of this, the biological mother of a child is an automatic guardian, so they are always a guardian of the child. So we're really dealing with the partner who is a non-biological parent to this child. And it's about ensuring that they have their legal rights vindicated. And I mean, this is a real issue. I mean, I know from having done clinics, having couples come into me, and this is just such a huge worry for them. So, you know, this is a really, really positive thing. As I said, we'll have to wait a few months to see how it pans out in real life. But on paper, this should address the issue. Now, there are lacunas in the law, and there are problems that won't necessarily be addressed even by the implementation of Part 2 and Part 3. Without trying to be overly legalistic, because I don't think that's necessarily helpful to people. Section 20 of the 2015 Act sets out the criteria in terms of a child that is capable of being recognised under the Act. And it sets it out in very simple terms. And generally a child who is born in Ireland through DAOR, born before the 4th of May 2020, is a child that is capable of that there is an application can be made. What's also very, very important in terms of Section 20 is the reference to intended parent, and that's the language that's used in the Act. So this is to deal with cases where generally consensual cases, so both parents are happy for this declaration to be made, happy for the order to be made. And at the time of conception, at the time that the DAOR is done, the other parent is the intended parent of this child. So this is done entirely consensually. The donor is generally not known to the parents. It may be traceable, but the intention is from the outset that this other parent will be the parent of this child, and that is the intended purpose of it. So I think that is very, very important, because you look at the criteria under Section 20, and then you look at Section 21, which is the process by which this is done. So it is done by making an application to the district court. Now, unusually, because a lot of applications to the district court don't involve affidavits or don't involve having to swear affidavits, and I suppose an affidavit is basically a written version of what your evidence would be. So it's what you are saying under oath, and you are saying that this is the case. And when it's on consent, generally the grounding affidavit shouldn't be too complicated, but it is a requirement under Section 21 of the 2015 Act that both parents swear sworn affidavits. So it's important to advise people of that. If this is a contested application, if this is a situation where there is an argument about whether they're a parent, then that'll have to go before court. But, you know, that's not the process that is envisaged under Section 21 of the Act. So what's envisaged under Section 21 of the Act is that this is an application made to the district court. And again, I haven't seen any court forms yet, so I don't know how this is going to precisely play out. It may have to be on notice of motion with grounding affidavit. It will have to be on grounding affidavit from both parties. And they set out the circumstances, they set out proofs, they set out how they qualify under Section 20. And as I said, primarily it would be that the child was born in Ireland, or if they weren't born, I don't have the legislation in front of me because I can't bring it up on the computer because I'm trying to do this. But if they were born outside of the country, or if they were conceived outside of the country, it was done in a situation which was lawful. So I mean, there are certain proofs that you have to satisfy, and I don't know if Anne-Marie's checklist is going to be how quickly that can be made available, but it's really, really useful in terms of setting out exactly what the proofs are that are needed. And that's really useful to even be able to give that to practitioners. But one of the main factors in this is that there is, they are, as the legislation sets out, that the other parent is an intending parent. So it isn't really a situation where you have to be able to show that there was some intention in terms of having this bond and having this parental relationship. So I think that is very, very important. In terms of Section 21 of the Act, it does make reference in Section 21BC to Section 20 to what Section 22 2B. Sorry, this is where all the sections get confused in my head. But that they would be an intending parent under the provisions of Section 21C. And what I can do in terms of the forwarding a paper is setting all of that out. Now, as I said, I mean, setting out all the different sections of the 2015 Act, I don't think is necessarily going to be too helpful to people. But it's just really, really important to understand in terms of basics and in terms of, you know, what we need to prove. And as I said, at the moment, we're dealing with a situation where we haven't seen judges interact with Part 2 and Part 3 of the 2015 Act. So we're not fully sure to how they are going to deal with it. In terms of Section 20, you know, how you show you're an intended parent, how you demonstrate the proofs. Again, we'll need to see how the court deals with that and addresses that. I have seen with regards to Section 6C, which is a section that deals with people who aren't a parent, but are seeking to gain guardianship because either they have had de facto, the child has lived with them for 12 months, or they've had parental responsibility for 2 years, and they are trying to demonstrate that the guardians either are unable or unwilling to exercise parental control. That's been interpreted by different judges, you know, very differently. So I think we need to see how this will unfold under Section 6B and with regard to Section 20 and Section 21 of the Act. So we'll have to see that. Another important, sorry, the dog's in the background. Another important thing is that we have to be cognizant of Article 42A of the Constitution. So if the child is of an age where their views and wishes can be ascertained, then those have to be ascertained, and that's a specific provision within the Act. And how that is done, whether it's done through a psychologist, a guardian ad litem, but I think if the child themselves were to say they were resistant to an application for guardianship from the non-biological parent or the other parent, then it's arguable the court just wouldn't, depending on their age, wouldn't make that order. It's also
Katie, just 5 minutes. 5 minutes left. Is that okay?
Yes. Oh, I'm at the end. So no. I mean, I think so. You know, those are the important sections of the Act. I think the important thing is to, if it is a consensual application, that you're able to go and ground an affidavit, I absolutely believe that you should go to a solicitor, because it's just a little bit more complicated than normal district court applications, and just demonstrate that you come within the criteria in terms of Section 20. And as I said, I can send on Section 20 and Section 21. I can't get them up on the computer at the moment. I can try and get them up on my phone, but generally speaking, you know, the situation that you have to, the essential proof is that they are an intended parent. You should be able to prove if there is a situation where it's donor-assisted reproduction. You should be able to get those proofs in order and show that that is the case. As I said, a biological parent, if that is the case, because it is not always the case, because sometimes it is the case that neither parent is a biological parent, but it is a donor-assisted reproduction. But again, it's about getting the proofs in order in terms of bringing the application. And I think the next speaker is going to speak to you in terms of the registration process. And I think, you know, as I said, I think in practical terms, he's going to be more useful, because in terms of the court order, just once you satisfy the proofs, in theory, you should just be able to go before a district court judge with your grounding affidavits, make that application. If it's on consent, it really shouldn't be that difficult. Now, there is a provision that you can attach the Attorney General, and the court can do that of their own volition or on application from any party. But again, and I've seen this with Section 6C applications, if this is on consent, if there isn't a difficulty, it's very unlikely that the Attorney General, the Chief State Solicitor's Office, will take any view on it, because it is, you know, this is the legislation of the land. So now it may be that a court requires you to do that. There's also a provision that the court can attach another party, another notice party, and sometimes they will attach the Child and Family Agency. But again, as I've seen it with the Section 6C applications, if there isn't any issue that the Child and Family Agency have, they're unlikely to get involved in it. And for most of these cases, it's going to be, if it's on consent, it should be relatively straightforward. So it's just a matter of complying with the requirements under Section 21, satisfying the criteria under Section 20. And as I said, there's a fantastic checklist from Anne-Marie, which is probably going to be better. And the next speaker is fantastic and has a fantastic presentation in terms of registration, which I think is really, really useful. And I think it's going to be more practically useful to people, maybe even than the court process. So listen, I'll leave it at that.
Thanks so much, Katie. Excuse me. Thank you. And that was off the top of your head. It's very, very impressive, your knowledge of the law. So thank you so much for that. And I think there's a couple of questions coming in just around the proofs that you mentioned. So what I'm going to do, I've asked Anne-Marie there if she wouldn't mind just briefly coming in on that before we go to Brendan, just to talk a little bit about the proofs that will be required by the court. And she's going to share her checklist that we spoke about, you spoke about there in the presentation.
Great. So I just couldn't, I'm just
not at all, Katie.
Technology, I couldn't get Section 20 up.
So I'm just going to hand over to Anne-Marie Whelan now, and Anne-Marie, if you want to talk about the proofs, and then we go over to Brendan.
Yeah, sure. So I'm just going to share my screen because I happen to have this checklist open that Katie has been talking about and kindly complimenting. Thank you. So I'm just going to talk through it so that people are fully clear about what is covered within the CFRA and who can apply at the district court level for a consent application. and then the necessary documentation around that. And Katie quite rightly referred to an affidavit, and that is a requirement of the legislation. So I'll talk a little bit about what has to go into that affidavit. So if I share my screen now, you should be able to see the checklist. Now, can you see that, Paula?
I can.
Perfect. I'll just increase it so I'll actually go to one page. There we go. Okay. So the top box that you can see there is the criteria, and all of these boxes have to be ticked for a child to be capable of recognition, or an intending parent to be recognised as a parent of a particular child. So the child has to be born in the Republic of Ireland, because it is a registration within the Republic of Ireland that we're concerned with. The child has to be conceived prior to the 4th of May. And given the current situation, I don't anticipate any children being conceived under a DAR procedure, because I understand that the fertility clinic can't actually provide services at the moment. So just that if anybody is pregnant at present, that child that ultimately may be born over the next couple of months could still be recognised under this provision. Any children conceived after the 4th of May won't be covered under this section. Prospective or the future looking provisions of the Act. The child has to be conceived via a donor-assisted human reproduction procedure, which used a donor. And in this context, with same-sex female couples, it will only be donor sperm. Reciprocal IVF is not covered under the legislation at present. So just be conscious of that. The procedure itself, retrospectively, can have been performed in Ireland, or it could have been performed abroad. So I know a number of couples who've travelled to Spain or to other European states where they've had a procedure done and the child is being born in Ireland, and that's fine retrospectively. If it is performed abroad, though, there has to be some level of proof that the person who performed the procedure was legally entitled to do that. So that you did attend at a clinic, that it was a practice and they were recognised. At the time of the conception, the second parent was the only intending parent of the child. So that does limit it to a second parent. So the birth mother, and in many of our family situations, could be the wife or the cohabitee or long-term partner who happens to be female or recognised as female. In this context, an intending parent is defined, and you might be able to read that at the bottom, in relation to a child who was born as a result of a DAR procedure, a person other than the intending mother, who at the time of the procedure was aware of the performance of the procedure and undertook to care for and exercise responsibilities towards any child as the result of the procedure, as if he or she were the parent of the child. So that somewhat presupposes that your relationship was existing at the time of the procedure. So I know a number of couples, you wouldn't have the option for marriage or even civil partnership if you had a child, but that you are aware of the procedure, that you may have signed forms with the clinic to consent in some cases. That's fantastic proof of this, but at least if the relationship was subsisting at that point in time, that can prove that element. At the time of the conception, and this is key for a number of couples as well, that the donor was and remains unknown to the mother and the intending parent. So this is only applicable to situations where the donor sperm was an anonymous donor or a traceable donor, which is somebody that the child might have access to their details later on down the line, but the parents don't actually know. So that does rule out known donors. At the time of the court application, they remain unknown. And at the time of conception, the donor was not an intending parent of the child. And that rules out reciprocal IVF, but it also rules out the families where the donor is known and is actually involved in the parenting of the child from day one, which does occur some of the families that we're aware of. And at the time of the court application, the birth mother is the only person recorded in the child's birth registration. So I know as well that there are some couples who did add the father, the sperm donor, as the father and was recorded as the father. Those situations are excluded from section 21. Okay, so they are the criteria. If you can't tick yes to all of them, or all of them bar number 4, where NA is permitted because it wasn't performed abroad, section 21 unfortunately does not apply. Now, if it does apply to you, the documents that you take involve completing a district court summons. The district court rules have been redrafted. I'm not sure what stage they're at, but they will be available come early May. And that sets out the summons that has to be completed. And generally for a district court level, it captures basic information in terms of the parties, in terms of what's being requested as a court order. And it's a standard form type document. I wouldn't be overly worried about the completion of that. The child must be named as a party on that. And that's at least for the court to say it's in respect of this child that this order is being made. There has to be a grounding affidavit of the birth mother and a grounding affidavit of the intending parent. And the legislation sets out that there has to be a statement that section 20 applies. And that's based on all of the criteria that we looked at from 1 to 9 above. There has to be a statement that the second applicant is the intending parent and there isn't any other intending parent. And confirmation of the birth mother's consent. So if you are a birth mother, that you're consenting to the application of the intending parent to be appointed as a parent of the named child. And then similarly for the intending parent, statement that section 20 applies, statement that they are the intending parent, confirmation of their consent, and then any additional detail around proving points 1 to 9. Now, one thing that has been raised over the past number of months, and some of you might be affected by, if a clinic has closed or it has changed ownership, you might be a little bit worried about, well, I don't have proof from the clinic in terms of a procedure that was actually took place in that clinic. So what we have to look at from a legal perspective is what's referred to as a best evidence rule. So if you are capable of getting proof from the clinic where you had treatment, and it can confirm the date of the procedure, it can confirm that the intending parent may have actually signed a consent form, things like that. Any of the criteria from 1 to 9, you can get correspondence from your clinic to set that out. That's huge corroborating evidence for the fact that section 20 applies, and that's great. And for foreign clinics as well, that correspondence could include reference to the fact that they were legally authorized or permitted to undertake the DART procedure. That ticks that box as well. In some cases, it might be a question of getting a legal opinion or local confirmation from a register that the particular clinic was entitled to perform that. That's not required for an Irish clinic, but it is required for a foreign clinic. Now, in extreme cases where none of that is available, the legislation requires the grounding affidavit to set out the proofs. So at a very, very basic level, if there are difficulties, it is possible to make the application based on the birth mother and the intending parent stating that section 20 applies and the criteria and how those criteria were met. But that's the absolute lowest bar. And I suppose the risk there is that you get in front of a cantankerous judge. And as Katie pointed out, this hasn't been exposed to judges yet in terms of applications because they won't happen. And they can't happen legally until after the 5th of May. Given the current situation that we're in, we don't actually know when we will be capable of getting access to a court. But until they do actually start going before judges, it'll only become very clear then if there are going to be issues. My best advice on this, and I should say that it's not legal advice, I am a parent, I will be applying, and it's based on that solely, is that if you can get a letter from your clinic that sets out points 1 to 9, you will be going a long way in terms of supporting your application. I hope that makes a little bit of sense, and I think we can adapt this a little bit for wider circulation if people think that that's of benefit. So I'm going to stop sharing my screen now, Paula, if you want to take
Thanks, Anne-Marie. That was really fantastic, Anne-Marie, in terms of, I think, grounding us into the proofs and what type of documentation we should be looking for. Just, I suppose, one question before we move on to Brendan, and then we will be coming back to, there's a lot of questions coming in which we need to come back to. But just one quick question there on the fact sheet, Anne-Marie, or the proofs, can you go back over that question, that's if you can put not applicable? Could you just clarify that again?
The simple question there is, was the procedure performed in Ireland or not? If the procedure was performed in Ireland, you don't have to worry about question 4, you can mark it non-applicable. If it was performed abroad, it has to be proven that the person who performed the procedure, or the clinic that performed the procedure, was legally authorised to do that.
That's great. So basically, all questions you have to answer yes for section 20 to apply. And including if your procedure was abroad, then that question has to be yes as well.
Yes.
Yeah, brilliant. All right, folks, and thanks for sending in the questions. They're fantastic, and I'm documenting them here, and we will come back. I'm going to hand over to Brendan O'Loughlin now, and then we're going to come back at hopefully around 8:30, 8:45, and then we'll open it up for questions. We still have 45 minutes before we close at 9:30, okay? So I'll hand you over. Thanks, Anne-Marie, so much. I'll hand you over to Benny now for Brendan for his presentation. Hold on. Sorry, Brendan. And I'm just going to bring up your slides.
Okay.
I hope. Hold on.
I'll take off my glasses. I don't need them. Make me look good. So, before we start, really, I just want to. Are we ready to go, Paula? Yeah. I've lost the sound.
We can hear you, Brendan. Sorry.
Oh, lovely. Sorry. Okay, just I'm not used to not hearing people laugh at my jokes. That's all. That's good. Anyway, just to say thanks very much for the opportunity. We've been dealing with Paula for the last probably year and a half on this, and the amount of work that's gone into it, it's fantastic. And I'm not sure if TJ is with us, Paula. He was going to say a few words as a registered
I was just
general.
going to say hello, Brendan.
That's him there. He wants to.
No, you don't have to worry about me. You can fire ahead. The time is running short. But good evening to everybody. If you can hear me, I'm TJ Fleming. I head up the General Registrar's Office, and Benny has been the lead on this project for quite a while. And as he has indicated, he has been working with Paula and others in the court service and the Department of Health in trying to, when it comes to the registration of their births, it's certainly to make the process as smooth and as administratively light as possible once the necessary court orders have been put in place. So rather than detain you, we'll listen to Brendan, and we'll be available for questions after that.
Thank
Okay.
you, TJ.
Okay, Paul, hit the button. It's just important before we start is that we're dealing here with a re-registration. So by its very nature, it means that the birth has to have been registered with us beforehand. I know there's been a few questions there about registering births, and if the birth has happened already, the birth will be registered in the normal manner, in effect, and then we can proceed with the re-registration process. There is a separate process for registering births, which I think would need a separate seminar to deal with. So in terms of the first line there, obtaining the court order, you've just heard Katie and Anne-Marie go over how you can get that. And we don't intend in GRO to look behind the court order. So once you've obtained the golden ticket, if you like, then effectively we are going to accept that as proof of the detail that's on the court order, and that the name of the parent and etc. will be as per the court order. So once you have the court order to say, you can apply to GRO. I'm going to give a very rough overview of the process first as we go along, Paula. And we'll process the claim then centrally in GRO with our headquarter building in Roscommon. So what we intend to do with that, in effect, is be able to interact with the parents then, just to iron out any issues that might be with the application form, and just to make sure we have all the details ready before we process the application. So our idea then would be that we would then notify the parents, and we have an SR title there, and that's a superintendent registrar. It's a title given to a supervisor of a registration area. And the law dictates that the SR has to give permission before the birth can be re-registered. So we'll coordinate all of that. They're HSE employees. So we will then go into our computer system here, CRCS, and we'll set all the information up on the system, and it'll be read-only information for the registrar. And then we will give a notification to the parents, and we'll outline again what you have to do in the last step. You attend whichever local registration office suits you, and you'll be able there to physically sign or register, which is like an e-pad, and your signatures would be recorded then on subsequent birth certificates. And that is the overall view of the process as we're going to try it out to work. So we'll go into a bit more detail. So basically, in terms of who can apply for the re-registration that we're talking about, not the court order as such, but it mimics the court order in effect. So the mother of the child can apply to us directly. The person who has been declared as the parent can apply. And if the child is over 18 and has got the court order, then the child can apply as well. We're obliged then, if one of those people apply, we're obliged to notify the other parties that an application has been made. And I suppose that's to stop somebody effectively putting somebody's name down on a re-registration without their knowledge, in effect, you know. So how to apply? We are currently, I don't know if you're aware, but the registration offices are closed at the moment due to the pandemic. So we actually have an online birth registration form up at the moment, and we got emergency legislation passed last week to allow people to register births without actually attending a registration office or physically signing a register. So we're going to kind of piggyback on the same technology, if you like, and we're going to have that application form available to download on the MyGov portal. You can then either email the completed form to us with a copy of the court order, obviously, or you can use the old-fashioned method and post it basically when it's completed with a copy of the court order to our AHR section in GRO in Roscommon. So once you have that and you apply, we'll be ready for you. So what information are we looking for? And this will be all given in a note before you actually fill in the form. We'll give a guidance note as well. So a couple of small things to think about beforehand, and that one of them is the surname of the child. So when the birth had been registered, the child would have been given a surname. And in most cases, if it's a single registration, that surname possibly is the surname of the mother. Now, there will be a facility for a change of surname if both of the parents that are nominated on the court order wish that to happen. And when I say we'll be interacting with the parents, that is the kind of thing we'll be coming back to the parents with. So for instance, if both haven't signed for the new surname, we'll have to keep going back to say, well, unless we get agreement here, the surname will remain at that which is on the register of birth. So that's the kind of interaction we'll be doing with you. So the surname can be the same, as I say, or it can be amended to be either or both of the parents. And that will be as per the court order. So you can have a hyphen, You can have whichever format you want. It's up to yourselves. And also, you can pick a different surname from those two, but you would have to apply to us then and indicate why it is you want a surname that's different from either of the parents, and we may be able to look at that for you. The second item we'd be looking for people then is I've called this parental label, and it's basically on a birth certificate. It just identifies each parent named on the birth certificate. So on birth certificates at the moment, you'll see mother and father. Now, as part of the implementation of the CFRA, we actually changed that now, which allows anybody who's registering a birth to pick a parent as a label instead of the traditional mother and father. As of from last week, we've only had about 10 to 15 couples who have availed of that service. And one of our reasons behind it was we didn't want the birth certificate to, if you like, identify somebody as having a parent label, because they are a re-registered birth under a donor birth. So anybody can have the title or the label parent on. So in terms of the parents at the moment, or the labels at the moment, the mother of the child in terms of registration legislation, it's always the person who gave birth to the child. And that person can pick the label mother, or they can pick the label parent. Now, they more than likely will have the label mother already on the system. So the system will now allow them, if they wish, to change that label to parent. And then the named parent of the child on the court order, if that parent is female, then the only option available there is the label parent. And if that parent is male, then that parent can have the option of either picking father or parent as their label. We then obviously will have to have the form signed and dated by both parents, particularly when they're indicating the surname difficulties. And again, we will always interact with them before that and get it all done and dusted. So, as I say, we'll validate the court order, and that's simply just us making sure that the information on the court order is correct and there's no fake court orders coming into us. There is as far as we can see, that when the court order is actually granted, a copy or reference is sent to GRO and Roscommon outlining the details of the court order. So we actually will have that backup information to validate as well. We may have to contact people. It depends on the type of court order that's been issued. There is a court order that can be issued whereby another person is down as the father of the child. And in that situation, there is a different type of court order that can be got to actually name a parent. And if that is the case, we then have to contact the person that's written down as the father of the child. And that is to give them due process to indicate that their name will be coming off the birth certificate and another name coming on. I think it could be rare enough, but it may happen as well. And again, we'd always interact with the parents when we see that type of court order coming into us. Again, we just check the surnames to make sure that they're as part of the registration rules. And again, that the label details are correct as well. And then we go into our own system. It's called CRCS, and we start the process of re-registering that birth. Now, actually, I spoke with a pre-meeting this morning, and I got a figure for how much this development was actually costing the department. And I gave a figure of about 60,000. In fact, that figure is nearly €250,000. I went back, there was different stages. And I just mentioned that to show that there's been a huge amount of money and time put into this process. It's really treated very seriously by us, and we really want to get it right and make sure that people who've gone through a long, long wait to get this to happen, that the system will operate properly for them. We'll then contact both parents and the superintendent registrar when we're ready to re-register effectively. And then basically when you've got that re-registration from ourselves, and one or both of the parents then can attend whichever local registration office they wish to attend. And at that local registration office, then the registrar will complete the process. So effectively, they'll hit the submit button that puts that information into the register of births, and in effect overrides the detail that's already on it. At that stage then, both parents will be asked if they wish to sign the register, and that's just an e-pad, and your signature then will be recorded on the birth cert, and then that amended birth cert replaces the original one on the system. And that means, in effect, that whenever you look for a birth certificate for that child, the details on that will reflect both parents and whatever surname that you've picked. And I think that's us done. We can't see anything going wrong. That's my final joke. And we're hoping, as TJ said there, that you'd appreciate that we've put a lot of work into trying to make this as painless as possible, but it has to be done within the legislation that we're dealing with as well. So it's kind of a balance between the two. Thanks very much.
Thank you so much, Brendan and TJ. And I do want to just acknowledge really how really proactive and positive the GRO's office have been in relation to putting in the new system and really dealing with us and keeping us informed, and just all the time you've given to us to meet and go through the process as you develop the stages. So I really do want to extend our thanks as LGBT Ireland and from the wider community, just for your proactiveness and positivity. So there's plenty of questions flowing in. So I might just start going back really to Katie and to Anne-Marie first of all, because I have to just have a look at the questions there for Benny, but is really to ask about, a lot of people are asking, is a solicitor needed in terms of the court process?
And this is where lawyers differ.
I would say it is probably safer, certainly in the first few months, because you could be dealing with judges who don't really know how to navigate Section 20 and 21. I mean, I agree with Anne-Marie. Like in theory, it should be quite simple. The grounding affidavit shouldn't be complicated. Where there is consent, it shouldn't be difficult. But it might be better to at least even have a consultation with a solicitor.
Yeah, I suppose, like, I mean, my view on it is, and I'm actually coming from a perspective of having practiced. So, I mean, it wouldn't place me in huge difficulty to be able to access these documents and to try to put them together myself. And I'd be comfortable and confident with that. What I would say to people is that if you feel comfortable and if you want to do it yourself, I do believe it is an accessible process at a district court level. I would highly recommend representation at a circuit court level if there is a contested issue. But if you do feel comfortable attempting to do it yourself, there's nothing to stop you from doing that. If there's anything particular about your circumstances that isn't straightforward and you have any doubt whatsoever as to whether you're covered or not, in that case, I would recommend that you at least seek legal advice and talk it through with a lawyer. I hope that clarifies.
And then there's a couple of questions in around, if you have guardianship, a court order for guardianship already, then is this process necessary? Yes.
So guardianship and parentage, in terms of a court order as a declaration of parentage to allow for re-registration, are very different legal processes. So even if you benefit from guardianship now, or you are looking to apply in the near future, you still have to apply for a declaration of parentage if you want the birth cert to be the registration of the birth to be re-registered and have both parents' names on the birth cert.
Yeah, I would agree with that. I think the declaration of parentage is separate from the guardianship, and you would need to have that in order to be able to go to the office in terms of saying, I want to re-register the birth. I think guardianship alone is not going to be sufficient in that respect.
Okay, thank you. And then I might just bring, Brendan, you might come in here as well, or you may need to. Would the speakers talk to the fact for parents who, or for people planning parenthood? Okay, so the Children and Family Relationship Act, what does that mean for them? So for people here who haven't conceived yet and don't conceive by the 5th of May, what does this Children and Family Relationship Act mean for them?
I'm happy to talk to that. And Brendan might come in. I know you're developing a separate process for new registrations. But in terms of actually qualifying under the Act, there are even more limitations. There are certain criteria that won't apply going forward. So when we went through the checklist, the requirement that the child is born in Ireland still applies. The ability to use a foreign clinic ceases. So the child has to be conceived and born in Ireland if the conception occurs after the 5th of May. Also, in terms of donors, the only permissible type of sperm donor is a traceable donor. So in terms of the child getting access to details about that donor when they turn 18, but also the donor will have to have signed a consent form that's in line with the Irish legislation. And that's partly for data protection reasons, partly for permission to go on the donor conceived register, which is established by the CFRA. So at the moment, there's probably 0 sperm donors that comply with that provision. So it remains to be seen over time how fertility clinics deal with accessing donors. Sorry, I actually need to correct myself on that. Going forward, known donors, if a clinic will allow for a procedure to take place using a known donor, that will be permitted. Retrospectively, it's not permitted. So any child conceived prior to the 5th of May using a known donor isn't permissible. Also, in terms of reciprocal IVF, it's not recognised under the Act up to the 5th of May for conceptions. But some of you may have noticed that Irish fertility clinics had started offering that procedure. After the 5th of May, it may be recognised, but that still hasn't been legally clarified. So there are definite changes. There's a difference between children conceived prior to the 5th of May and children conceived after the 5th of May. But I'm hoping that I've hit the key points there. Child after the 5th of May has to be conceived and born in Ireland. So foreign clinics are out. Known donors may be permissible if the procedure occurs in an Irish clinic, and that may possibly cover reciprocal IVF as well. So I hope that clarifies a little bit, albeit that the clinics don't appear to be functioning at the moment. And then in terms of re-registration, there's no need for a court process if the child is conceived after the 5th of May. There's automatic legal recognition. So in terms of registering for the birth, it will be a new registration, and that's a process hopefully Brendan can speak to.
Yeah, just in terms of the new registrations for us, it's a new section in the Act, new section 19A in our Act, and that actually will start with the donor facility have to give a certificate to the parents, and without that certificate, that birth cannot be registered as with us, because that starts off the registration process for us. And there's a lot of interaction between the clinic and the parents, and from what I can gather, there is requirements on both parties to notify the Minister for Health the outcome of each procedure, and then when the birth is to be registered, the parents can't register the birth until the Minister for Health indicates to GRO that it has been a donor birth. I'm not sure why that's in the format it's in, but that's how it is. And if a birth is registered without that, under the ordinary registration system, that birth then would actually have to be re-registered as a donor registration. And one of the reasons behind that is that the child has a right to know who the donor is once they turn 18. And there is a badly written provision in the Act that indicates that if a child who is over 18 arrives at a local office to get a copy of their birth certificate, that the registrar must notify the child that they are a donor child and that there is information regarding their the donor on a website or on a register in the Department of Health. So it's a very, very cumbersome piece of legislation that we're certainly looking at in terms of GRO, trying to streamline a bit better and get it amended. But that's our understanding on the registration of it.
And just a question in there from Evelyn, I think it is, in respect of if you have a baby at the moment, so you have a baby born in February or March or April indeed, is it worth holding off to register the birth? Because it's not, is it? Because they're just going to be a re-registration.
There has to be a registration before there's a re-registration under Section 21. So the declaration of parentage would still be required. So unfortunately, and I saw the little baby there, so congratulations. You have to register in the normal course, which unfortunately means just the birth mother going on the certificate, and then down the line you will have to make an application for a declaration of parentage because the child was conceived prior to the 4th of May.
Okay, and another one there, probably Anne-Marie.
Yeah, that's my
sorry,
understanding.
Brendan.
Yeah, that's, I would
No,
agree with
confirm
that.
that. Yeah, sorry.
And then Anne-Marie, just maybe you'll take this, or Katie, is that if you have one child already and you have sperm in storage, what is the provisions under the CFRA?
There is a 3-year amnesty from the 5th of May for gametes in storage. And what that means is that if there is an existing child conceived using that donor, and mostly in these cases donor sperm, and you still have samples from the same donor, you are allowed to use those samples for up to 3 years after the 5th of May to try and conceive a sibling. But that's just it's a narrow exemption that's built into the legislation. The position is different for embryos. So embryos in storage, there's an unlimited, there's no limitation on the use of embryos. But I think that's because that creates a whole host of legal and ethical issues around embryos. But for donor sperm, it's 3 years after the 5th of May.
Thanks, Anne-Marie. Brendan, one for you there. What if a child has been registered already for the name change purpose? So that's from Mary. Mary, I might just unmute you there if you want to frame that question to Brendan.
Yes.
Yeah,
Hi, sorry. The question was, we already have one child who was registered at birth and then re-registered when the second child was born, for her name to match, her last name to match the second child's name, if that makes any sense. So she was registered and then she was re-registered 2 years later. Can she be re-registered again with this when we get the court order?
So on the second on the first re-registration, it was in fact a name change as opposed to
yes, for both parents to be. So she now has the last name of both of us.
But sorry, Mary, it was just the surname change on the. It wasn't. Yeah.
Yes.
Oh. Okay, so it was just a name change.
Yeah.
Like that sounds like just an amendment. It sounds like just an amendment.
Yes, to change her name.
Yeah, that wouldn't be that's not a re-registration.
Okay, grand. Okay.
Yeah, so what we would, if you are re-registering that birth,
yes,
the first birth, Mary, what would happen there is that's a re-registration for the court order when you're putting somebody down as the parent. And
Okay.
as part of that, then the surname change can be made as well.
Okay, yeah, no, they both have our name
As
already.
part of the re-registration process. Yeah.
Okay.
Yeah,
And
but then
Mary,
you don't have to, but one less thing.
And Mary, you've asked as well, and a few people have asked this, what age is a child asked for their opinion in court?
Well, there's no like strict age, but generally speaking, once a child is 6 or 7, they're considered to be capable of, offering their views and their opinions to a court. Now, it does depend as well in terms of whether that's done by them speaking to a judge in chambers or speaking to a guardian ad litem. And a guardian ad litem may be able to take instructions from a child younger than that. But there is nothing prescriptive. But what the High Court has said is that generally sort of 6 or 7 is kind of the age at which it would be appropriate for their views and wishes to be ascertained. And obviously the Constitution requires that.
Is that okay, Mary?
Yeah, okay.
Thank
Paula,
you.
could I just add in maybe 1 or 2 items there?
Of course, TJ. Yeah, please do.
Just in terms of people holding off for registration, I think it's best that you proceed with registration now, because there are entitlements that the child can avail of. Simple things like child benefit, but also the free medical card or the medical card for infants. So it's a good idea really to register, and then given that the pandemic closed down, it may go on for some time, and it's quite likely that the family courts may be out of action for quite a number of months. The family can suffer financial loss, and the child, obviously, it's important that they would have access to medical care. Not that they would be prevented from doing so, but registration also provides the child with their PPSN and their identity, and they have a constitutional right to all of those items. So we'd encourage you to register. You can't go into a registration office currently, but we have a facility available on the gov.ie website that the necessary form can be completed and sent into the registration office. So I'd encourage people to not to wait until the 5th of May, because when the 5th of May comes, we may be locked in for quite a number of months following that. It's so unpredictable at the moment. There was another question, and I'm not sure who asked it. Let me see if I can find it. Oh yes, information on the court's website. Brendan and I have been discussing this with the court's service, and they have made their preparations as we have, and we have engaged with them just to make sure that the process is as seamless as possible. However, the change in the court rules can only be signed by the Minister for Justice when the legislation actually comes into force. So it can't be done in advance of that, and that's why you don't see anything on the court's website. But once the Minister for Justice has signed the court rules, they will be published, and the necessary forms and guidance around accessing the facility will be published. And we'd hope that they do that on or about the 5th or 6th of May, once the necessary statutory procedures have been completed by the Minister for Justice.
Thanks, TJ. Leslie, has that's answered your question, has it? Yeah. Okay, thumbs up. Thanks, Leslie. And then just Brendan and TJ, just how long do you estimate the re-registration process to take once you've the court order's been sent in?
Well, not to speak over Brendan, who's our expert in this.
Australia.
Well, my instructions are we can register, we can get through the formalities if all the paperwork is in order, you know, within a day of it being received. I mean, I don't perceive that if there are any queries there, it's a relatively small community of parents that will want this facility. So we will prioritize, we will have a dedicated team of people who'll deal with that, and with the instruction to expedite the re-registration process. So it's not going to hang around our office terribly long. We already have quite a lot of experience in dealing with sensitive registration matters like this on the Gender Recognition Act, where, you know, within an hour or two of receiving the necessary documentation, we can have all the formalities completed. So I won't commit to the hours, but certainly, you know, within a day or two, we will raise whatever questions we have with the applicants, and then we will ensure that the registration, once it leaves our office, that it's available in the local registration service office for completion. A lot of these will possibly happen in the Dublin area, we would we will have an arrangement with the Dublin registration office that they will also expedite the registration service there, and that they will have a designated small team of people who will become expert in this, rather than all of their 50 staff attempting, you know, feigning ignorance of the process when somebody arrives in to sign the registration documentation.
Thanks, DJ. And just one question on how, will there be a cost to the re-registration process?
For the certificate, to get the certificate.
Currently no cost for registration, but as Brendan says, the law requires us to charge you €20 for the birth certificate.
Okay, and then in just a couple of comments in there around about Galway and Cork. It's the same process really, isn't it? And Limerick.
The same process, and we will be working with the registration staff there to ensure it's a seamless process as possible. And you know, we'll see what the level of business is, but it would imagine that most of this can be done on an appointment basis, and that, you know, that the parents would make an arrangement to contact the or to visit the registration office to sign the register.
Okay, thanks TJ, and thanks Brendan. So there's a couple of questions around this issue around sperm and the storage of sperm, and particularly for people who have sperm in other jurisdictions. So there's one question in there from Mary, so I might just go to you, Mary, or Marie. Where are you, Marie? Now till I unmute you, or can you unmute yourself, Marie? Marie, would you be happy to ask your question there?
Hello, can you hear me?
Yes.
Yeah, my question was just on the storage of sperm. So if we have sperm stored in Denmark, is it required as part of the legislation to have the sperm stored in Ireland, or can it still be stored in Denmark?
The legislation specifies in that portion that exempts sibling situations for 3 years, that the DAR facility, which is the clinic in Ireland, can only use sperm in that context where it has been, where they have acquired it prior to the 5th of May. Now, my kind of plain English reading on this, and other people might have different views, is that it would have to be stored in Ireland unfortunately. I'm in that position myself. I've one child, and we need to make a decision whether to purchase more from the same donor and to have it our clinic take ownership of it. But my reading of the provision is that it has to be acquired by the clinic.
And we have 3 years to do that.
Just very
Anne-Marie.
briefly, I think I would have to agree with that. I think that's what the legislation allows for now. Now, whether there will be amendments to the legislation which will make further provisions into the future, and that's something that needs to be looked at. But I think at the moment, no, I think Anne-Marie is right. I think if I were giving that legal advice, I would be saying it should be in Ireland, you know, before the operative date of the 5th of May. Now, that doesn't mean that there isn't going to be further amendments coming down the track.
So sorry, I think I'm getting a little bit confused there. So do we have to transfer the sperm before the 5th of May, or do we have 3 years to do it? Or is it the amnesty to use the sperm 3 years from the 5th of May?
So the amnesty applies from the 5th of May, but will only apply to sperm that has been acquired by the clinic prior to the 5th of May.
All right. Okay, thank you.
That's my understanding, and that happens to be the way that that particular provision was drafted. It refers to the DAR facility, which is the clinic, and it's written in terms of them performing a procedure, and they're prohibited from performing a procedure that includes sperm that doesn't comply with that, and that they have come into possession of, or that they have acquired prior to the 5th of May. I think there was another question came in there that was tangentially related to that. I might address that as well. So in terms of purchasing sperm going forward, the issue at the moment is that none of the sperm banks will have donors that comply with the CFRA. Now, that position is very likely to change. The consent forms for donors were drafted and approved in regulations back in November. And at least was that the sperm banks could start to use those consent forms. I don't know if they have, but over time they will start using them. And the hope is that a pool of donors will become available going forward. The problem for a lot of us is that if we already have children, it's almost guaranteed that our donors, you know, may not fall within that pool. So we have to be careful in terms of acquiring sperm before the 5th of May. But in terms of anybody without children or anybody looking for a new donor with traceable sperm, the interesting thing will be indicators from sperm banks, particularly the European ones who are willing to comply with the Irish requirements, that how they mark a donation as being compliant or not. So it will be possible to use the sperm banks, and particularly the European sperm banks, but it's a case of understanding if they are clearly demarcating which sperm donors are compliant and which aren't, particularly with the Irish legislation, because the donor conceived register that the CFRA creates is uniquely Irish. I hope that clarifies a little bit.
Breed, I've unmuted you there because you raised that question. Does that answer your question?
Not particularly. I don't know if I'm just not getting it or not. We have a little fella, he's half Danish, and we were looking to use the same donor in the future. Now, we haven't purchased any more samples, but I were wondering, would we fall under the category if we purchased them now? Would we still fall under the 3-year rule, or what way would it work going forward?
So as I understand it, you're in the exact same position as me. We used a donor sperm from Denmark as well. And the legislation suggests that if we purchase the sperm now, but also ask that be held by the Irish clinic that we intend to use, then we benefit from the 3-year amnesty.
Right.
So it does seem to be the case that we would have to purchase extra samples, and that we would also have to ask our clinic to store them to enable them to legally perform any DAR procedure using that sperm. I
And
hope that's a little bit, probably not the news that you want. I certainly don't like having to make this decision in terms of how many samples are going to be enough. You know, it put a lot of pressure on that decision. But unfortunately, that does appear to be the impact of the legislation.
And with the COVID-19 crisis, are we going to get an extended time period on that so the clinics are opened back up, so then therefore we have time to purchase and have time to ship it back to Ireland?
That would require an extension or an amendment to the legislation.
Which is probably not going to happen.
It's certainly not going to happen before the 5th of May. Unfortunately. I mean, it could give us an argument in terms of asking for amendments going forward, but to be honest with you, God knows when that might possibly happen.
Great, thanks very much.
Thanks, Breed. Thanks, Anne-Marie. Fiona Duffy, there on your iPad. Fiona, can you hear me?
Yes, I am. Oh, sorry. Yes, I am here.
Fiona's on our legal strategy group. So is there any other comment you want to add to that, Fiona? Because I know you're fairly familiar with the legislation too.
No, I think Anne-Marie has more than adequately dealt with all of the questions. Well done, Anne-Marie.
Thank you, Fiona.
Thanks, Fiona. And then can we just go back to this point about the child, and certainly that would be in my case as well. My kids are 13 and 10. You know, what is the process if the child is party to the court process? What would that look like in reality? Do they have to go to court?
I suppose we don't know yet how this is going to play out. In terms of other provisions of the 2015 Act, particularly Section 32, which deals with ascertaining the views and wishes of the child in relation to access and custody matters. And what the court has been inclined to do is to ascertain their view through a guardian or through a psychologist, or by not having them directly come to court. So I would have thought that a similar principle would apply in terms of this. Now, I have had cases under Section 6C where the judge has directly spoken to the child and said, are you happy for your aunt to be made your legal guardian? And the child has effectively given her answer in court. But, I think where possible, best practice is that children should be kept out of the court proceedings as much as possible. If there is a way that their views and wishes can be ascertained without them having to come to court, then that's a preferable way to do it. But then again, there's obviously a cost implication to that in terms of paying for a guardian or paying for a psychologist. So I think a lot of that is going to be ascertained when we see how these applications progress. But certainly from childcare and certainly from ordinary applications in terms of maintenance and access, best practice appears to be that if you can get their views without them having to come to court, then that's preferable.
Katie, do you mind if I add on to that question, maybe frame it a different way? So, I mean, would it be common for the courts to seek the views of a child in a consent application? Like, I fully understand where a contested application might actually have a particularly negative impact on a child or change the practicalities for a child. But in terms of a consent application, would it be the norm for a judge to turn around and say, oh, we better ask the child whether they're happy with this, where the legal criteria for parentage is?
Different judges have taken different views on this, so I don't want to give like a definitive answer, but I have absolutely had situations where there's been consent access applications and they have insisted on getting the view of the child separately, because I think a lot of judges are worried about Article 42A because it says they shall ascertain the views and wishes and give them, give them due consideration, giving, and due weight given their age and level of, of understanding. So, like, I don't know how that would be interpreted by a court, but I can see a situation with Section 32 where judges would say, I'm not prepared to make an order as significant as this without, if the child is of an age where they can give a view. I mean, you know, if they're one, sure, they can't give a view about anything really. So you don't need to even be worried about it. And I think a lot of these applications will be made in respect of very young children. So in reality, it's not going to be an issue because they're not going to be able to give a view or a wish. But I mean, if it is a situation where, I don't know, the child is 7 or 10 or 12, I think a court is going to want to have that view, even if it's done through like a guardian or done through whoever. And the court doesn't allow really for guardians in private law cases at the moment. So I'm not sure. And this comes down to how all of this is going to work in practice, because we see what the legislation says, we see what the criteria are, but how this is going to work when it appears in front of judges and people are making applications. You would think when it's on consent and if it's a very young child, it's not going to be an issue at all. But for older children, I think depending on the court, they will want to know what the child thinks.
Thanks, Katie. And can you just, Isolt is asking there, just can you explain through a guardian what that means? What does it mean through a guardian?
So in this is a process which applies more generally to childcare proceedings, and that's where the court appoints what's known as a guardian ad litem, and that's somebody that just goes out, talks to the child in very child-centered terms, finds out what they're thinking, finds out what their views and wishes are, and separately gives their own recommendations as to what's in the best interest of children, and that applies within childcare proceedings. There is in statute a provision for guardians in private law proceedings, but it's never been enacted, it's never been commenced. So it's not there as an avenue now. There is what's, as I said, Section 32 of the Act, which allows for a court to direct that the views and interests of a child are ascertained. And as I said, I don't know whether that would happen in applications like this or not, because obviously it hasn't been commenced yet. We don't know how the court is going to deal with these. And I think the reality is that in most of the applications, it's going to be in terms of re-registering a birth. So it's going to be when the child is very, very young. So they're not going to be in a position to give any views or wishes one way or the other, even if the court were to direct a report. But if it were to be an older child, I mean, it is open to the court, and the court does have the power to direct that a report be ascertained in respect of the views and wishes of a child. But as I said, like so many elements of this Act, until we see how the courts actually start dealing with the applications, we won't know for sure. But I mean, Article 42A is clear in terms of, you know, where their views and wishes can be ascertained, and the legislation is very clear that they're to be made a party to the proceedings. So if they're an older child, conceivably that could be something that comes into, that has to be factored in by the court. Thanks,
Katie. One quick question, and then I'll hand over to Marie to ask her question. Just to clarify, because I know this is, we have to keep this clear. It is conception before the 5th or the 4th of May. Is it the 4th or the 5th?
Sorry, yeah, the Act itself commences with a date of the 4th. There's other regulations that commence the 5th. So the conception has to be prior to the 4th of May for re-registration.
So if you have your baby on the 3rd of May, you have to register that birth, and then you'll have to go through the re-registration process.
Yeah, and if you have the baby on the 5th of May, you have to register that baby in the normal course and re-register going forward. If you conceive the baby on the 5th of
Oh,
May.
sorry, yes. If you
likely to
conceive the
happen.
baby. Yeah,
Yeah.
okay.
So conceptions, DAR procedures, so the clinic procedure that actually creates the pregnancy has to happen after the 5th of May for the new process to apply, which doesn't involve the declaration of parentage in a court order. Conception prior to the 5th of May, or the 4th of May, really follows the re-registration process and has to be registered in the normal course anyway.
Okay, thanks, Anne-Marie. All right, Marie, are you okay to ask your question?
I am, yes, Paula. Just my question, I think Brendan mentioned earlier about for new registrations that they need a certificate to register the birth. So I'm just wondering, do we get this certificate from the fertility clinic that we used, and are they aware that we require such a certificate?
Yes, it's from Marie. It's from the clinic. It starts the process in effect, and you interact with the clinic then from there on in terms of the procedure and in terms of the result of the procedure, and then in terms of an outcome of a birth then as well. So it's a whole mapped out process in dealing with registrations with the clinic, and then the clinic liaise with the Minister for Health.
Okay, so our initial point is just we contact the clinic, we ask them for the certificate, and then they liaise then with the Minister for Health.
They have to give the information that you give them back to the Minister for Health. So my understanding is when the Minister is informed that a birth has occurred, that they record all of the details on the register, and that, if you like, looks back to telling us then to put a marker. When I say marker now, I'm using my inverted commas, on the system, which then in turn links back to when the child is over 18. That marker is viewable by a person on the inside of the system, and it tells them to tell the person that they are, believe it or not, tells them that they're a donor child and that there's information available to them on the register. That's the way it's written at the moment. As I say, we in GRO, we think it's a bit cumbersome, and it can certainly be done better than that, you know. So part of one of our objectives is to get that whole process changed and smoothed out.
Okay, so when that whole process is done, then Brendan, do we wait then for some sort of notification then back to, so we can go into the office and,
Exactly.
and sign? Yeah.
So when the child is born, the hospital, when a child is born, on every occasion, the hospital we have a birth notification, it's called. So that birth notification sits on the system, and a registration then is the completion of the notification. So the notification will simply sit there, and the parents will have been informed of this in advance, that they have to wait until they get the letter from the clinic, and all that system has to be done. But you know, it's because it's not immediate. The re-registrations are immediate in our opinion. So that's further down the line in terms of system development and in terms of how laying out procedures and to parents. And I know we've been in touch with Paula when that starts to become a kind of a real thing, that we'll start, like we're doing here, ironing out how the procedure will operate in practice and getting information to parents beforehand so they all know in advance.
But the clinics have been involved with the Department of Health in establishing or writing the regulations. So the form of certificate will be set out in regulation, I think, as far as we understand it. So it won't be, you won't be going into a clinic and discovering that they know nothing about this. So it is a legal requirement. So the clinics have been involved in discussions with the Department of Health for some time. Maybe Paula or Anne-Marie might comment further on that, because you might have more inside knowledge than we have on that. But so the clinics will be prepared to issue the necessary certificates to enable the legal process to launch. And of course, any child conceived after the 5th of May, the new procedures, there are a number of months there in which before the new procedures will kick in for children born after the 5th of May. Conceived after the 5th of May, obviously, let's hope everything runs to the natural cycle. So it'll be whatever it is later in the year before new births come to be registered.
Is that okay, Marie?
Yeah, that's perfect. Thank you.
Thank you, Marie. Folks, we're coming towards the end of the session, so I want to just pose a very lay person's question, if I may. But if anyone has a burning question, just if you want to put it in the message board now. Would you just, Katie and Anne-Marie, would you just talk through the steps? So say I go, the 5th of May comes along, I'm just forgetting about the restrictions, COVID restrictions for the moment. What do I do? So I have my child that I've ticked all the yeses in terms of your check sheet, Anne-Marie. What do I do next?
You next have to go about gathering the documents that are required. So the district court summons, as has been explained, the court rules can't officially change. We understand that they are pretty much agreed and they're ready to go. They just need to be signed off by the Minister for Justice, but that can't happen until the 4th of May. But once those court rules are available, there will be a template summons form, and that's the first thing that needs to be filled out. The next things then are the grounding affidavits of the birth mother and the intending parent. And that's where it may become a little bit more difficult in terms of drafting, that you may have to get access to some sort of legal advice or assistance to be able to complete that. Obviously, if a template affidavit becomes available at any point, we will certainly endeavour to circulate that to make it easier for people. Once those documents are together, it follows the kind of normal process for any district court application within the family courts, and that usually involves contacting the office and following their procedures in terms of getting the application listed before a district court judge to be able to go in and say, here's our paperwork. Judges obviously may have questions to ask, but that's how the normal process runs. Katie's probably a little bit closer to the practicalities on actual court applications than I am at this stage, but that's the basic process. The one thing I mentioned earlier that is key, that if you are in a position to get a letter from the clinic now, that you go and do that, just send it off or write to them or know that they're not operational in terms of doing procedure. They're still capable of receiving correspondence, and that you could just ask them to set out and confirm when the procedure happened, the type of donor that was used, the date of the procedure, and if there's any paperwork that they have that confirms that the second parent was an intending parent. You know, I know from my experience that my wife did actually sign paperwork with the clinic, and we can certainly rely on that for proving that she was an intending parent at the time of the procedure. So if you're able to get that sort of documentation, I'd recommend doing that now. And that's something that we can all do as a practical step while we wait to find out what the situation is with the courts. And then look at the summons, which we're not going to get access to a copy of till May. And then the grounding affidavit. You might be able to just start putting together notes yourself that might go into that affidavit. So, you know, you probably remember what date the procedure was. You remember which clinic that performed it. You know what date of birth your child has. So you can easily just put them down on a piece of paper. And even if you do go to a solicitor, we'll circulate that checklist, that you can bring that and you can bring your notes, and they can easily put together the affidavit for you and ultimately make the application if you want them to do that. But if you want to do it yourself, obviously it'll help you inform yourself as to whether you're comfortable trying to do the application on your own or not, as the case may be.
Yeah, I mean, I think it should be a situation where you should be able to go to the district court office get a copy of the relevant summons. Often there's people in the office that will assist you in filling that out, because people routinely bring applications without any legal advice. It's just a little bit more complicated because there's grounding affidavits involved, and you need to understand that in terms of the grounding affidavit, it is sworn evidence, and therefore you have to be clear and have all your facts correct in respect to that and have the effective proof. So, I mean, it may be even if you don't have legal representation, you just have a, you know, you even have a consultation with a solicitor. But a lot of solicitors aren't necessarily going to be experts in this. So it is going to take a little bit of time. And I think, you know, I think one of the reasons why I think Anne-Marie's checklist is so valuable is because it just sets out very clearly, rather than going through section 20, you know, and section 21 and what this says and what that says. It just says to you, look, these are the documents that you need to have. These are the qualifying criteria. These are the proofs that you need to have. So I think that is really useful. The court office should be able to help you out. I don't know whether it's a situation where a number of applications at the moment, because of COVID, are being dealt with on the basis of consent without parties having to attend court. So I don't know whether district court offices will consider these to be applications that, if there is consent of both parties, it can be dealt with by way of affidavit. We just don't know yet. Certainly in terms of the district court, cases I have are being put back to minimum July. So, you know, and I just don't know how quickly these applications are going to be dealt with. And I know that that's stressful for people who are in that situation, and they just want to get everything regularized, and they just want to have that, you know, they just want to have that court order and go and get re-registered. But as with any piece of new legislation, there's going to be a teething period here, a teething process. So we won't fully know. But I think the first step is to get in contact with the district court office, to get the summons as soon as the summons is available, to get advice from them about what you need to put into the grounding affidavit. I'm sure templates will come online, but they're not there yet. Certainly I haven't come across any. And to make it simpler, it may be easier just to get some legal advice. And even if that's a situation where you go to Anne-Marie or to FLAC or to somebody who doesn't necessarily, you know, have to be somebody formally representing you in court, but it may just make the process.
I can't, by the way. Could I just make the qualified barrister, but I've left practice, so I can't give legal advice. But if you happen to have a question, I might be able to give information.
Fair enough, Anne-Marie, but you might be able to guide them to somebody who can give them advice.
Absolutely.
Thanks, Katie. Fiona Duffy, you wanted to come in quickly there?
Yeah, just very briefly. There is that provision in Section 21 and Section 22 for the Attorney General to be joined as a party to the proceedings. So I think those proceedings may not run quite as smoothly as or as quickly as is being suggested, because the attorney needs to be joined if the order is to be binding on the state. So that whole joinder of the attorney is going to take some time. So just to bear that in mind.
Although I have seen it in terms of Section 29 applications in the Circuit Court for declarations in respect of divorce and marriage, and again the Attorney General has to be joined as a party. But if the information is given to them and they are satisfied that this is a bona fide application, yes, it'll have to go back. There'll have to be a second hearing date or a third hearing date. But generally speaking, they have enough work to be doing. So if it's a situation where they're satisfied that, you know, the proofs are in order, you know, generally speaking, they won't adopt much of a position.
Yeah, no, I'm not suggesting that they're going to be difficult, but I'm just saying that it will take time, because you went to court on the first day, you need to get an order, or at least the court might make an order joining the attorney. then you probably get another date. The attorney may not be in a position to attend or may not have looked at all of the papers or had the opportunity to look at all of the papers. So I'm just saying, it's not that I'm putting obstacles in the way, but I just think that it could mean, as you suggested, 2 or 3 visits down to the court, so that it won't all sort of magically happen on the first day.
No, and I think that's, I couldn't agree with you more. I mean, I think, you know, it is a situation and it has to be realistic, and people need to be advised of that, because it also is a situation where it's open to the court under the legislation to join other parties, and they may join the Child and Family Agency because they may just want to have that extra protection. So it's by no means a very simple application, but I think it may require you to go to court on a few different occasions. And that's one of the reasons why I'm gently suggesting that it might be easier for you to have some sort of legal representation, or at least legal advice. It might make that easier. No, I completely agree. If they attach the Attorney General, it just simply can't be dealt with on the first occasion.
Okay, thank you, folks. We're going to just...
Can I add in there, Paula, please?
Of course, TJ.
No, our experience of the Attorney General, which effectively joins us as a party to the proceedings as well, are that the delays occur when people don't seek to join the Attorney General at the earliest stage of the submission of the court documentation or application. Generally, the attorney won't have an opinion to express, and will possibly simply consent to the applications being made. The difficulties and delays comes when in court it's then sought to convince the judge that the Attorney General needs to be added as a party. So we would suggest that at the earliest opportunity, once as the court papers are being lodged, that the Attorney General is also copied with the paperwork.
Okay.
Yeah, and
may I just in relation to that, I think the legislation is clear that the attorney can only be joined at the request of the attorney, and that's so an order has to be made to join the attorney. I appreciate what you're saying there, but it's I think that's the way the legislation is framed, which isn't perhaps the most practical way of dealing with it.
Okay, we might just move on because we're coming to the end. So I'm going to go next to Camilla, and then I'm going to go to Fiona, the other Fiona here, to ask the final 2 questions. Okay, so Camilla, do you want to ask your question?
Yeah, hi, thank you for taking my question. Can you hear me?
Yes.
Yeah, so my partner and I will be starting an IVF process soon, and we are not married, we are not in civil partnership. So our question would be regarding cohabitant couples, how the new legislation is gonna impact us. Will that cover us if we tick all the boxes, you know, regarding the donor and the Irish clinic? How will that play out, you know?
Cohabitees are definitely covered. Unfortunately, I don't remember off the top of my head what the period of cohabitation is. I don't know, Katie, if you're aware of what's recognised.
Yeah, I think it's 2 years.
Yeah.
If you're having children, but it may be 3. Yeah, it may be longer if you're just in the process of going to have children.
Okay, thank you.
Okay, and Fiona then? Fiona, you wanted to ask a question? I've lost your question now, but...
Oh, you're all right. Hi, Paula. It's Fiona Delaney here from Galway.
Hi, Fiona.
I was just wondering, when we applied for guardianship for our son, we had just a letter from our clinic that stated we had gone to use their services as a couple, and we had used a non-anonymous donor. And it was just one straightforward, simple letter, and that covered us for guardianship. So it covered, like, that there wasn't another parent out there. Would that cover us for this new re-registering, or do we need to get more documentation from the clinic?
I think I had to get a similar type letter, and my view would be that that would be proof, like that would be a corroboration of what you're trying to prove to the court in terms
Yeah.
of procedure and the type of donor, and things like that. So, I mean, you might have a look at it again and just check it off with the checklist if we can distribute
Yeah.
that. And if it contains all of the information there, or most of it that you would get from the clinic, that's great. You can still use that.
Yeah, perfect. Thank you.
Thanks, Fiona. And then just one final question from the chat I'm going to throw in is from Suzanne around this question around the sperm, the donor sperm again.
Yeah.
I understand that after the 5th of May, only donors with the right paperwork on the registrar can be used to comply with the legislation. But if we have a past donor who isn't on the Irish Register, are clinics still allowed to use it in general, for example, for reciprocal IVF?
Okay, so from the 5th of May, for
Susan, I'll unmute you for this. Sorry, Suzanne. Yeah.
Question is that clear? Did I come across what I'm trying to ask?
Okay.
Did that make sense?
No, that makes sense. Doesn't make it's more so around. I understand that to apply to the legislation, it needs to be on the donor register so that it's traceable and all that sort of stuff. But I assume that same legislation wouldn't apply to other uses of it potentially. So I'm just saying, could the clinic still use the sperm and saying, oh, but that means the second parent may not be able to be on the birth cert, but we can still use it for the procedure in itself for donor siblings?
Okay, so the way that legislation is written, the clinics are prohibited from providing procedures that won't allow for proper registration. So,
okay.
the idea here is, and part of the fundamental reasons for the legislation being drafted the way it was, the establishment of the donor conceived register to protect the child's right to their genetic heritage. So that's why the norm under the legislation going forward is that a traceable donor is used in all cases. And then an exemption has been carved out for sibling cases for that 3-year period, but only in those cases. Does that make sense?
Oh, it does. It was just kind of in my head now. There's a whole pool of donors that just
absolutely,
won't be applicable
and they
to
won't be able to be used in Ireland.
Yeah. Okay. Thank you very much for that.
Okay.
Hey folks, so it's just coming up to 9:30 now, so we will wrap up. Just, I suppose there's a couple of comments around the information from tonight. How will that be available? So we will be putting the recording up on our website on lgbt.ie. We have a parenting section in there. We'll also share Anne-Marie's fantastic checklist. We'll just really talk to you, Anne-Marie, about when we can share that, but we will try and get that out quite quickly. And then we also, Brendan, would it be okay to share your presentation or have that up on our website?
Yeah, that's fine. Yeah, I might reword it a bit better.
Okay. Well,
yeah, and then send it up. There's no problem. No problem at all.
Brilliant. So listen, folks, for everyone that came along this evening, thank you so much. And I know it's hard going with in the online format. So thank you all for your patience and for your lovely comments and all your questions. And a massive shout, thank you so much to Anne-Marie Whelan, to Katie Dawson, to Brendan O'Loughlin, to TJ and to Fiona as well for coming on and just giving us our expertise. And I suppose everybody is doing this, Anne-Marie and Katie in particular, and Fiona as well, on a voluntary capacity. So we really do appreciate your time.
And
so
thank you, Paula. I think everybody's very appreciative that you organised this information event, and hopefully everybody's got some benefit from it.
Absolutely. And can I just say, Paula and everyone, look at, like a lot of things, this probably won't run smooth as we imagine. until we get a little bit of practice at it, we get a little bit of feedback, and we get some better ideas as to how to do complicated stuff a little bit more simply. So, you know, we welcome your feedback. We don't mind criticism, but we do like people to say if there is something that's awkward or otherwise, or just appears to be administratively difficult, if people can criticize with a helpful suggestion, it really works well for us, because it gives us ideas as to how to overcome them, because we're not in your position as such. We're on the other side trying to operate what is a complex legal framework. And like a lot of things, while we think we make it simple, it's not always the way it appears to you. So if we can be of further help, or if you think there's some better way of doing it, you know, do let us know. We'll keep the channels open. Paula has been wonderful, and Maria has been wonderful as well in educating us. So look, thanks to everybody for facilitating.
Thanks, TJ. And just finally, I would like to hand over just to Stephanie Lord from FLAC, because this is a joint event with FLAC. And I suppose we are proposing that we can run follow-on FLAC clinics if people feel that they need those. So I'll just hand over to Stephanie then to have the final word.
Hi, can you hear me?
Yep.
Yeah, I just wanted to say thanks to yourself, Paula, and Brendan and Katie for speaking, and Anne-Marie Whelan, of course, as well, on behalf of FLAC. And just to mention that if there is a need for people to get more advice and more information, more detailed information, we can host a FLAC clinic on that, and I'll work with Paula to try and facilitate that. Obviously it will be online given the COVID restrictions, but that's just to let people know that that's that facility might be there as well. And so just thanks for that, that's all.
Thanks so much, Stephanie. All right, everyone, thanks so much, and stay safe and well. And yeah, hopefully we'll be able to process our applications soon.
Please God.
All right, thanks,
Thank you
folks.
so much, Paula.
Night. Thank you.
Bye.
Bye.